Assalamu alaikum wa rahmatullahi wa barakatuh, and welcome to another episode of Legal Ease, the show that converts legal jargon into legal ease. Now tonight my very special guest is Willem the Klerk, who practices as an attorney in Johannesburg under the name and style of Willem the Klerk Attorneys. He was admitted to practice in 1991. He holds a degree, a BCom degree and LLB degree from RAU. I think the previous degree was from University of Northwest, and an LLM from Wits University. Before going full-time into legal practice, Willem was a lecturer and adjunct professor at the University of Witwatersrand, where he taught students and assisted the poor with legal problems at the Wits Law Clinic. He was also the director of the Wits Law Clinic for a number of years. Willem's current practice is focused mainly on freedom of expression, defamation, hate speech, media law, and related topics. He regularly acts for media houses, grassroots publishers, organizations, and individuals in protecting their right to freedom of expression on the one hand, and the right to dignity and privacy on the other. Digital publications, social media, and the internet has presented new and interesting challenges for the law regulating expression. Willem has published widely on issues ranging from access to justice, clinical legal education, and media law. Willem, good evening and welcome to Legal Ease.
Good evening, Ashraf. Thank you very much.
As we've indicated in the introduction, your area of expertise is that of expression, is freedom of expression. Now, what do we understand by freedom of expression?
Ashraf, well, it is the right to speak your mind, and it's the right to tell the truth, basically. Freedom of expression is entrenched in the Constitution under Section 16 of the Bill of Rights, in terms of which everyone has the right to freedom of expression. And that includes the right to artistic freedom and the right to academic freedom and, of course, also media freedom. So it's a very powerful right, and it has been described by the Constitutional Court as the cornerstone of democracy. So in South Africa, we are very fortunate to have a very liberal approach to freedom of expression. And particularly, political expression is given a lot of leeway in the law. But I think it is important to understand that all rights are limited,
Yes.
and that there's not a hierarchy of rights. In other words, one right doesn't automatically trump another.
Right.
So the Constitutional Court has said on many occasions that just as we have the important right to expression, we also have the right to dignity and the right to privacy, which must all be juggled. It's a constant balancing act for the law to decide which right in any particular situation would trump the other.
So there's no equality of rights. This is a bundle of rights, and they all, as you've pointed out, flow from the Bill of Rights. And the Bill of Rights is, I think, in Chapter 2 of the Constitution. But just to simplify, what do we mean by the Bill of Rights?
Well, the Bill of Rights is really, it's a section in the Constitution. So it's one of the chapters in the Constitution that set out the basic human rights that all people in this country are entitled to. So from the right to dignity to the right of a fair trial, all of these rights are listed in the Bill of Rights.
And I think that also includes, as you've pointed out, the freedom of expression. Now, expression goes beyond what we would normally term freedom of speech. So it's not just speech. Speech is one kind of expression.
Yes.
But it's not limited to speech.
Absolutely. You know, speech is one kind of expression, like you say, Ashraf. But of course, there's various forms of expression. You can express yourself artistically. You can express yourself through movement, through the written word. So expression, like cartoons, for instance, we see is a very important form of expression in our media law. So expression takes on many different formats.
As you've pointed out, art, I think, is a particular form of expression. I think the most famous recent case was that of the portrait of President Zuma that was defaced in the Goodman Gallery in Johannesburg.
Yes.
I mean, there was very clearly a kind of expression in an art form, but the opposition to that was also a freedom of expression, wasn't it? I mean, the people that went and objected and painted over that painting were also expressing themselves.
Yes, they were expressing themselves, and interesting, I mean, the president himself was exerting his rights to dignity.
Yes.
In saying that particular portrait by Brett Murray, the spear, is undermining his constitutional right to dignity. So it was a very, very interesting debate that took place at the time. I must say, you know, just for having had that debate and having seen the end of that whole dramatic saga was fantastic to see how democracy is really at work.
I think the other famous case recently in the media, Willem, was that of Kill the Boer, Kill the Farmer.
Yes.
I think the protagonist of the song was saying that was a struggle song that they were using in the present context because they believed that the struggle had not yet was not yet over. It was still many things still to be achieved. But you know, what's your interpretation of that particular case, and how did it go for the protagonists of you know, of people wanting to sing the song?
It was a difficult situation. Like you say, the people who wanted to sing the song claimed that that was part of their struggle heritage. It had special meaning to them, and that they did not sing the song to try and promote the killing of Boers. That it wasn't hate speech. It meant something else to them. Of course, then you had the other side of the argument that said, well, the song on the face of it incites violence, and those people who challenged the right of the song to be sang cited examples of farmers being killed on their farms in great numbers. So they claimed that the song amounts to hate speech. The matter went to court, to the Equality Court, and Judge Colin Lamont was adjudicating. And there was a lot of speculation as to where this matter would end up. You need the wisdom of, you know, you need to be very wise to make the right decision. And fortunately, I think for everyone, that particular case was settled.
Yes. But I mean, I think what you're saying is, while there is freedom of speech, there are obvious limitations to that as well. I think in this present case that we're speaking about, the particular song, the limitation would have been surely a song that incites violence or outrage or impairs the dignity of a particular, let's say, section of the population will not be allowed just to be used.
Yes, absolutely correct. You know, Section 16 of the Constitution, the Freedom of Expression section, continues after granting the right to freedom of expression. It expressly excludes certain forms of expression from protection.
Yes.
And for instance, propaganda for war is excluded. It's not regarded as protected expression, and so too the incitement of violence. And most importantly, hate speech is not regarded as protected speech. So there is immediately a limitation placed on your freedom of expression.
Now, Willem, I think just an interesting offshoot from that, if you recall, there was the caricature and the cartoons against the Prophet Muhammad, peace be upon him. And there was outrage from the Muslim world and the Muslim community locally. Having said that, there were still certain newspapers that went ahead and published it. Now, on the one hand, it's the same argument. It is saying freedom of expression as opposed to the limitations placed on that expression, simply because one of the elements would be that it might incite racial violence or racial hatred or racial intolerance, or it may impair your dignity.
Yes.
It's well known that there isn't a single sketch or portrait or resemblance of the Prophet, peace be upon him.
Yes. Well, that's right. You know, we in South Africa, we saw the extreme reaction by Muslims to those cartoons being published overseas. And that was probably a fair indication of how people would react to it being published here. And of course, you know, just like expression is guaranteed, so too is the right to religious freedom. So in a country such as South Africa, with many different religious groupings and ethnic groupings, one needs to have a culture of respect and tolerance of others' views. And you need to draw the line sometimes in different places. And where you draw the line is, of course, the difficult question.
Right. So let's expand a bit on this, on the limitations itself, in the context of very recent events in the Gaza. Now, that conflict obviously had a bearing in South Africa as well. And in South Africa, you had various groups either for or against the incursion in Gaza. And that led to a lot of public debate about certain words and slogans. But particularly, there is a charge of anti-Semitism that is very, very often used if you have to say something against, let's say, the Jewish religion or Zionism itself. You know, how does one juggle these issues?
Well, I mean, there's so many emotions involved, and people feel very passionate about on both sides of this whole Israeli-Gaza saga that has been playing itself out. And it was interesting for me to see the uproar around the schoolboy at St. David's School in King David's School in Johannesburg.
Jason Brumberg, I think.
Yes, it was. And Joshua. Yes. I think he posed in Palestinian gear on a Facebook photo or something to that effect. And he was at risk of losing his position as deputy head boy or something like that. And I thought to myself, well, you know, that is exactly what freedom of expression is. It's the right to demonstrate what you believe in. And be it in a predominantly Jewish school, you should be allowed to express that opinion, because it's certainly not hate speech, and it is certainly accepted expression.
Willem, I'd like you to please pause on a very, very interesting point right there. We're going for a short break, and we'll join you after the break. Please stay tuned. And welcome back to the next segment of Legal Ease, the show that converts legal jargon into legal ease. Now, tonight, my very special guest is attorney Willem de Klerk, and he specializes in the area of law dealing with freedom of expression, which used to be known previously as freedom of speech. Now, Willem, just before the break, you were saying something very interesting about Joshua Brumberg's right to self-expression while belonging to a particular community and attending a particular school. It so transpires that a formal complaint has been raised with the Human Rights Commission by the parent of another student in the same school that has been apparently suffering from bullying simply based upon her or his views on the Palestinian issue. I think in Joshua's case, it was not just him, it was three people, three students who were attending a debate in Thailand. It was a debating debate, in fact. And they happened to wear Palestinian scarves and posted those images on Facebook and had certain things to say. Now, the scarf itself appears to have given insult. You know, what's your comments on that whole saga?
You know, it's very complicated. It's the law really gives a very wide spectrum for people to express their views, except if it amounts to offensive speech or to, well, even offensive speech, but hate speech in particular. And of course, an important part of a thriving democracy is the right to say unpopular things, because it's only through unpopular statements being made that a debate is raised. And through that debate, hopefully society grows and comes to accept various different ideas on things. But yes, you know, I think to suppress speech, one should be very careful, just because it may offend or you may not agree with it. You know, I think one needs to keep clear guidelines in mind when you start disallowing by law certain forms of expression.
Right. Now, is there a age cutoff here, Willem? What about minors? You know, can they also say what? You know, where's the freedom of expression? Where does it stop, and at what age?
Well, it's interesting. You know, I think everyone, of course, is entitled to whether you're a child, whether you're an adult, you are entitled to have your say. I mean, your parents may not always allow that, but in principle you are. We've seen an interesting case in recent time concerning children, and that was two schoolboys at a school in Pretoria who took a photo of a teacher, and they superimposed it, the face of the teacher, onto a photograph of a naked man. And they published this, they put this photograph up on in the passages on the notice board of the school. And the teacher took great offense to this photograph, and he said his dignity is being impaired.
Right.
And this matter went all the way to the Constitutional Court. It took years. And one of the arguments in defense of the children was that they were children, and that this was a schoolboy prank, and that one should afford more leniency to when it comes to children expressing themselves. Well, the Constitutional Court found that didn't accept that argument ultimately, and found that the children defamed the teacher, and they were ordered to pay money.
Mm. So there isn't an age limitation; it's a responsibility that's really called in question here.
I think it's a responsibility, and I think the law, as much as it gives people rights, so too it imposes obligations, and part of those obligations are to act responsibly in what you do and what you say, and to be sensitive to how what you say may impact on others.
And just a reminder to our viewers that the lines are open, and as always the telephone number is 011 086 77 00 1, 2 or 3. That's 011 086 77 00 1, 2 or 3. Now, Willem, part of what our discussion seems to center around is the aspect of defamation. Does defamation itself have any role to play in freedom of expression?
Yes, absolutely. It's got a very important role, because defamation, the law of defamation, essentially inhibits or limits a person's right to free speech. On the one hand, you're given the constitutional right to express yourself, But on the other hand, people have the right to dignity and the right to privacy and the right to a good reputation. So what the law of defamation does, it tries to strike a balance between dignity really and expression on the other hand. So a number of rules have crystallized over time as to what your limits of speech are when it gets to defamation.
Mm-hmm.
You know, and in short, if you say something that will impact, that has a negative effect on another person's reputation, that would be regarded as unlawful unless you can justify it. And of course, the way to justify it is to prove that what you said is not only true, but is also in the public interest. So it was necessary for the public to be informed about that truth. And it's hard, it's difficult to prove truth and public interest. You know, one of the favorite expression that the courts often use is, well, you know, is it in the public interest that this disclosure was made, or was it merely interesting to the public? And there's a big difference between the two.
Right. What's the difference? I mean, it sounds the same, but it's obviously very, very different.
Yes, it sounds the same. I mean, to take an example, it may be interesting to the public that a famous sports star or celebrity has had an affair with another person. But, you know, that may merely be interesting to the public, and there may not be a legitimate public interest. I think legitimate public interest is something like, you know, corruption or politicians acting improperly and that sort of thing.
And not the private lives of individuals. I mean, it shouldn't matter.
No, it shouldn't matter. I mean, the private lives of people are considered their private lives, and even celebrities and even politicians are entitled to their private lives. But once again, one can infringe even on that if there is a public interest, and that we saw many years ago with the former Minister of Health, Mantu Shabalala Misimang,
yes.
Where one of the Sunday newspapers got information, they got hold of her medical records.
Yes.
Now, medical records are highly private things.
Yes.
And they published things from these medical records that showed alcohol abuse and other things. And the court sanctioned the publication of those private facts because there was an overwhelming public interest.
Now, Willem, there are two very interesting things that have come up recently. On the one hand, you see certain members of a political party dressing up as gardeners and domestics. On the other hand, you see two students going to a party dressing up as domestics. On the one hand, it is an expression of identification with the working class. On the other hand, it's taken to be an insult. I mean, where does one really draw the line here on freedom of expression?
It's very difficult. Once again, you know, that particular example, it was two students of a university, and I understand that there was a party, a dress-up party, and they thought that it was funny to dress up as black domestic workers. And you know, it's a race thing. The students were white, and people took great offense to that. Many people took great offense to that. And the students were expelled from the hostel and being disciplined and all the rest. You know, some people say it was just students having innocent fun. There was nothing wrong with that. But there's another view that I think is the better view, and that is that, you know, perhaps those students were naive, but perhaps they should be educated, made to understand that one cannot do certain, you know, what is funny to you may certainly offend others. So it's a race thing. There's no getting away from that. When the EFF dresses up as domestic workers and attend parliament, the context is completely different. So really the context is determinative.
Willem, I think America is a very interesting place to actually have a look at how freedom of expression has turned out. There's two things that come to mind. One is a recent documentary that I saw, The Most Hated Family in America. And this family is basically a church. But in the church, they do not tolerate gays. And they walk around with placards. And I'll come back to that point. There's a call on the line. But they take placards and they walk around condemning gays and saying that they are the cause of the misery of the world. But we have a call on the line. Caller, please go ahead.
Hello, Assalamu alaikum, Ashraf. How are you?
Wa alaikum salam. Well, thank you. Welcome.
And greetings to your guests. And I must tell you, I enjoy your program every week. It is so informative, you know. What I want to know is, we in South Africa and other parts of the world as well, you see the newspapers write some false information about Islam. For instance, they would say that Islam promotes jihad, killing of other people, yet we write to them and we explain them what is the meaning of jihad. Then you find afterwards there's another article to say that Islam promotes the so-called, female circumcision. We tell them this is not Islamic, but yet they keep on doing that. Do they have that freedom to do that? Don't you think the editorial board should censor those things which we have already corrected? I will listen on the air.
Thank you for that, Willem.
Ashraf, yes, it's a very interesting question that, I think there's a difference between your freedom to express your views and to publish simple falsehoods. And there's no protected right to broadcast incorrect facts or falsehoods. So if the newspapers do publish or attach certain meanings to Islam, then and that those meanings are incorrect as a fact, then one can take certain steps, and you've got remedies. You can, for instance, apply to the Office of the Press Ombudsman and ask that the newspaper be sanctioned, and perhaps even publish an apology for the falsehoods that they have been publishing.
That's a good enough guide. I think what the caller was also concerned about is the repeated breaches of, let's say, the proper journalism. Because if I recall correctly, what you were saying is you corrected one version and then they would go on and you'd point out the facts and they would go on. But I seem to think that there was a sense of frustration. But thank you for pointing out the remedies there. Willem, we were talking about this matter in the States. Now, the other international matter that received total outcry was when Prince Harry attended a fancy dress party in Nazi uniform. Now, in certain states in the United States, the Nazi signage is outlawed. In others, they consider it as freedom of expression. So again, various ways and various jurisdictions dealing with it. But the church was very, very interesting, and they said it was their freedom of expression, and they would stand their ground. What's your view on something like that?
Well, there's a debate going on at the moment. In South Africa, a very similar type of situation. There was a columnist of a daily newspaper, and this now happened a couple of years ago, John Kwelani, if I remember correctly, and he wrote a column in the Daily Sun extremely critical of gay people. Very harsh words used, saying that it's unchristian, that they are worse than animals. I may be wrong in the details, but it was that kind of message that was brought across, and many people took great offense. And in fact, the matter was referred to the Equality Court. A complaint was made against him, and the Equality Court actually found that Kwelani's column constituted hate speech. But that is now under constitutional review. And the argument, the other side of the argument is to say that it's certainly not, it's not hate speech, because in order for you, hate speech is two things really. It's the propaganda of hatred based on race, religion, gender, that sort of thing. But the second leg of hate speech is an incitement to do harm. And Kwelani's argument is that there was certainly no incitement to do harm to gay people, and therefore it's not hate speech. So that although an unpopular opinion, it should be an opinion that is tolerated. And as hard as it might be for many people to accept that that kind of offensive speech should be allowed, in a democracy, it's a necessary evil in many instances.
Willem, I'd like you to please hold on to that thought. I think it's very important. We're going for another short break, and we'll join you after this break. Please stay tuned. And welcome to the last portion of Legal Ease, the show that converts legal jargon into legal ease. Now, my very special guest tonight is Willem de Klerk, an attorney who practices in Johannesburg and is an expert in the area of freedom of expression, hate speech, and defamation. Willem, we were discussing something very, very important before that, the two elements that would qualify a particular expression to be hate speech. Could you just repeat that?
Yes, absolutely. Hate speech is very particular. It's, on the one hand, the first leg or the first requirement is that it must be propaganda of hatred based on race, gender, ethnicity, and religion. That's the one leg. But that alone is not good enough to qualify as hate speech. The second leg is that that propaganda of hatred must constitute an incitement to do harm. So the two must go together for it to qualify as hate speech. And we've seen, just in recent time with the whole Israel and Gaza situation,
yes,
so many opinions being expressed and so many things being said. For instance, there was a high-ranking politician in the Western Cape that said that the time has come for the Jewish Board of Deputies to be punished according to the biblical rule of an eye for an eye and a tooth for a tooth. Now, that, in my opinion, comes very, very close to hate speech, because that incitement to violence aspect, I think, is present there. Then compare that, for instance, to an opinion expressed by ex-minister Ronnie Casuals,
yes,
that he made a comment that said that Israeli policies may be compared to the Nazi regime. Now, also a very powerful comment to be made, but not hate speech. So Casuals' comment, there was a complaint made to the Human Rights Commission, and they rejected the complaint to say that that is a justifiable opinion.
Well, I think, on the same vein, Zionism has been compared to apartheid. There's many mentions of this all over the world. Now, obviously, that gives insult to the people that believe in Zionism. Yet, there are many resolutions, etc., comparing Israel to an apartheid state. Would that be per se hate speech?
No, I don't think so. I think it's clearly an opinion that is being expressed. And if you ask the person who expresses that opinion to explain why, they will cite all sorts of facts to support the opinion. But, whether or not that opinion is a good opinion, whether it's an unbiased opinion, whether it's objectively justifiable, all of it doesn't really matter for it to enjoy the protection given to it by law. It's a controversial opinion, and many people will differ with it. But hate speech, no.
Now, you know, even recently there was a particular comedian who took the K word to its most extreme, and he actually made a joke about it. But recently there's been a case that very clearly indicated that the use of the K word is absolutely unacceptable.
Yes. Yes, and that's absolutely true, Ashraf. That word in the context of this country and in the context of the history of this country is regarded by law to be completely unacceptable. And in fact, the most recent example that I saw was, I think he was a lawyer or an ex-law student who said this word and was charged criminally under what we call crimen injuria. And he was found guilty and a fine was imposed. And he appealed all the way to the Supreme Court of Appeal, saying that he didn't mean it in a certain way and whatever. And the appeal court refused him leave to appeal, was emphatic that the use of that word is simply unlawful, and those who do use it may be not only pursuits in terms of civil law for remedies, but may be criminally charged.
And you know, again, going back into the context of the Middle East, there were reports of mobs shouting death to the Arabs. In fact, I think there was a wedding between an Arab and a Jewess, and the groom's parents tried to obtain a Supreme Court injunction unsuccessfully, but the police were deployed to keep out the protesters against the wedding, you know, for an area of about 200 meters. But you know, a statement like kill the or death to the Arabs, or there are no innocents in Gaza, I mean, does that amount to hate speech?
Well, it certainly comes close. You know, there's many nuances in language, and the context in which statements are made determines the meaning of those statements. So, you know, a statement, if you look at it in isolation by itself, it may look like a perfectly innocent statement, but put it in the context, in the right context, and that statement may assume a wholly different meaning, much more sinister meaning. And that's a difficulty with law, and the law of defamation and free speech is to determine the meaning of words in the context in which they were said. And certainly the death to the Arab would, in my mind, there's absolutely no doubt that would constitute hate speech.
So it'll only become actionable if it's repeated here. I mean, you can't quite prosecute somebody across the border for any manner of speech. For example, President Mugabe's utterances on gays or the recent events in Uganda, you can't prosecute that. You might make some kind of objection. Just a reminder that our lines are open, and the number is always 011 086 7700. Now, Willem, what about social media? That is now something very new. When I say new, I mean it's new in our lives for about a period of 10 years or so. But right now, it is at such a high level of interaction that almost everyone has got a smartphone and is using social media in one way or the other.
Yes, it's incredible. You know, things like Facebook and Twitter, it's just opened up, it's enabled everyday people to what we call self-publish. You know, before you would write a letter to the newspaper and they would take a look at it and see if they liked it before they published it. Now you don't need to do that. You just publish your views at the click of a button. And you know, I think people don't think before they do that. It's a strange thing. People post all sorts of statements on social media and perhaps not appreciating the public nature of social media, or simply not thinking about it. And there's been, the law is slowly starting to deal with more and more cases involving social media. And certainly there's been a few cases of people who made Facebook statements that were sued, and damages was awarded. So one has to be extremely careful what you do on the social media. In the one case, I think it was Judge Nigel Willis, he said, well, the social media is there because it's supposed to be social.
Yes.
It's not there for you to attack other people.
Yes.
So one has to be very careful of social media.
I think one all too often forgets how really wide social media is and how accessible it is to everyone. A few weeks ago we heard about how everything that you say, write, research or read is recorded on the internet somewhere. So there is there's no privacy any longer. I suppose the only privacy you could have are your own thoughts. But obviously social media itself recently was also very much in the news when I don't know if it was a local case, but hold on, we have a caller. Please go ahead.
Hi, man. I am watching the program at the moment.
Yes.
Yes, so I can hear you going on about the K word.
Yes.
Yes. So, well, my question is to you. I'm a colored, and is it all right for them to call me a bushman in such in that word? Isn't that also amount to hate speech?
Willem?
Well, certainly it's not only limited to the K word that is out of bounds, and the law would not limit itself to that. So, there's a range of offensive words that refer to race. So certainly that word that you have mentioned to me, as far as I'm aware, there's not been a decided case about it. But you know what? If it's a racially offensive term, then the law will give you a remedy, definitely.
Does it answer your question, caller?
Yeah, it answered my question. It's just that I feel that it's just about, maybe I do sound racist or what, but it's just a black thing.
Now, I think what Willem is saying, given our history, certain words used in a certain way gave rise to offenses. For example, the K word, when used overseas, and the example was given by Trevor Noah, no one would even blush if it was used in the United States. But certainly here, given the historical context and given the racial divide and the difficulties that we've had in South Africa, would certainly give rise to that. I think what he's saying, in the same way, the word that you've used has also the same kind of connotation. What he's saying is there hasn't been a tested case yet of the use of that word. Is that right?
That's right, Ashraf. And you know what? I mean, there was another example not too long ago where a person from the white race took offense to the words white trash. And he complained about that. And the court certainly listened to him. And the court accepted that particular term aimed at a person of that particular race could definitely be unlawful and offensive.
Does it help you?
Yeah, but what I'm saying is, it's the same thing that we can say about what's happening to the what you call it, to the what you call the farmer.
Yes.
Yes.
But we won't get into that now. But I'm saying it's the same thing that if something else has been done to other races, it seems like it's been brushed under something. But if it's done to the blacks, it's like it causes havoc and you understand what I'm saying?
No, I think the difference is those cases found their way into court. And the case that you might be citing hasn't yet found itself into court because there hasn't been a complaint. In the cases that we're speaking about, somebody had a complaint. In the case of Kill the Boer, Kill the Farmer, there was a complaint. And that case was prosecuted in the Equality Court. So it's not that one is given more value than the other, because look, in this case, the Kill the Boer was used, The K word was used in a different case. Both have different sets of people affected by it, but they pursued their legal remedies.
Yes, there was not too long ago, there was a song. Remember, there was a song that gave great offence to Indian people.
Oh.
Or it was a poem. I can't
No, it
remember.
was a poem, yes, by a gentleman in Natal.
Yes, that's
Yes.
right. And I mean, certainly the law is not going to make a difference between races as to who may be offended and who may not.
I think the remedy is you must go to court. Thank you for your call. We have another call on the line.
Yes.
Please go ahead.
My name is Oscar.
Yes, Oscar.
I had a case of labor, unfair labor, unfair labor practice.
Yes.
And then I was, we had a protected strike.
Yes.
And then after the strike, I was dismissed. And then I think the case was referred to court, and then the court never takes place. And I'm still sitting, waiting for the court up to now.
Oscar, if it's referred to the labor court, you must please go to that labor court in your area and speak to the registrar of the labor court, because the labor court's role is very, very busy. The fact that they haven't come back to you doesn't mean nothing is being done, but the onus lies upon you to go there and check with the registrar, get the file out, go and see him, ask him, is there a date arranged, are they looking at dates, is the hearing coming up? So you have a very practical solution. Please go and see the registrar of the labor court.
Okay.
Okay, Oscar. Thank you. So, Willem, we now have very few minutes just to wrap up. I mean, I think we've covered a huge topic in a very, very short time. I'm sure there's so much more to talk about. I think particularly was the aspect of the limitations on the freedom of expression. And I think everything is in its context. And everything would go around the intention of the parties at that time. Well, what is very clear is that if you intend to be nasty and cause harm, then that is what is going to weigh against you in that particular circumstance.
Yes. Yes, certainly your intention is a huge factor. But you shouldn't forget that through naivety or ignorance, you can very well unintentionally also cause great offence. Like we saw the students, the Pretoria University students dress up. So, but intention is very important. And but you know, like we say, on the one hand, one has to be careful not to offend. On the other hand, in a democracy, you should be tolerant, and one should not take offence too easily, because you must accept that there are divergent views in a democratic state, and they all have a space under the sun.
So what you're saying is you have to be a little bit thick-skinned to participate in a democracy.
Absolutely. You must be thick-skinned, especially if you're a politician.
That's interesting. Just in closing, we have very, very few seconds left. Defamation that you mentioned, you can claim damages, right? What's the high watermark for damages for defamation?
Not a lot. You know, I think the highest was probably around 230,000 Rand in South Africa. Your average defamation, you can look at about 50 to 100,000 Rand.
So it's not like the American system where you claim 2 or 3 million Rand.
No, or the UK system where you really get big amounts of money. It's quite conservative here.
But it will probably go that way in the long term.
It might.
Willem, thank you very much for your time tonight. It was certainly a very, very interesting topic. The topic of freedom of expression versus hate speech, and what is defamation, and the limitations to that, and the fact that the freedom of expression is guaranteed in the Constitution is a very, very huge right that people have they can enjoy. Thank you once again for your time and your input here, and thank you, the viewers, for having joined us tonight. Please stay tuned for the next episode of Legal Ease next week, Thursday, same time, same place.
Thank you.